Everyone, it's middays live from the Element Well studio. We welcome to the program now. It's law professor Christopher Green from the University of Mississippi Law School. Professor, always good to see you, sir. Thanks for joining us.
Thanks for having me.
All right, so the former president is going to be busy this week. It looks like he's got lots of legal matters in which he will be attending or that will be argued for or against him on various fronts. But more importantly, last week we had arguments in front of the United States Supreme Court as to whether or not the state of Colorado can remove Mr. Trump from the ballot. And all indications are, Professor, that the Supreme Court is going to overturn the state of Colorado's actions. Certainly that seems to be the case. Even the more left-leaning justices on the court seem skeptical of Colorado's action. What was your take on it?
Oh yeah, that was definitely how I read it. When Justice Kagan came in and started really going on a tear about the pragmatic problems that she saw about having different states do different things, I immediately thought, wow, okay, this is going to look an awful lot like this Chiafalo case from 4 years ago, which she wrote, and a lot of people in the original meeting crowd thought Chiafalo was terrible, frankly, and I think they're probably going to be similarly disappointed with the way that it looks like they're gonna resolve this. I just came back from a conference in San Diego where some of the leading proponents, pro and con, of the Section 3 theory, we had a debate Saturday morning. And some of those folks, kind of bless their hearts. They look at the arguments they're presenting and they say, well, once the U.S. Supreme Court sits down and really thinks about it, they will not have the ability to say things that are wrong. And I think they are quite able to say things that are wrong. So if you read Federalist 68 about the whole point of the system is to have different elections in different states. It's not one presidential election; it's 51. If you read Federalist 68, you're going to be very disappointed with the kind of opinion that they seem to be getting ready to write. But the Federalist paper is not going to take life and knock the pen out of Justice Kagan's hand.
Well, and I can't remember which justice specifically, Professor, but one actually made the statement. I'm paraphrasing a bit. I think to counsel, to the plaintiff's counsel there, that, hey, should we let one state decide who is our president? That's essentially what you're arguing here. Could that power be vested in just a single state?
Yeah, that was Justice Kagan. That was her first initial thing. Okay. And the response that, well, no, we're not. We're not making a decision for the whole country. We're just making a decision for our electoral votes. And it's kind of chaotic, but that's a feature, not a bug. From the perspective of current pragmatics, it looks like a bug. And the fact that it was a feature according to the original design of the system, if it looks buggy now, the court seems to be willing to try to make the system less buggy.
Something we've talked about when the arguments were being heard last week is while we were on the show. But we dove into the explicit language in the Section 3, 14th Amendment, and that's where it gets a little confusing, Professor. Hopefully you could help us out with this, where it says
I can make you more confused.
A person could be disqualified if they, quote, engaged in an insurrection. So, sir, isn't that subject to interpretation, engaged? It doesn't say explicitly that they must be convicted, which is a much easier standard to prove. This just says engaged.
Right. So there's all this language that, really, if you take it at face value, it seems like it's just self-executing. And just as soon as you do it, you become subject to these disqualifications. There's a whole bunch of questions about, well, when he sends the tweet saying, come out on January 6th, it will be wild. Just how wild was he thinking at the time? And, then this whole series of tweets on the afternoon, what counts as engaged, and then so engaged in insurrection or rebellion against the same, which could be the Constitution of the United States or the United States, and then or given aid or comfort to the enemies thereof. So who counts as an enemy? A whole bunch of questions about that issue. What counts as aid or comfort? To what extent can you be? So if the president had a duty to send people over and clear out the Capitol, but he didn't do that, could that be deemed as giving comfort? That's one question. But this is subject to a lot of these are several of these terms. I mean, insurrection, engage, aid, comfort. All of these have fuzzy boundaries, and there's just inherently gonna be this happens in the law all the time. Questions about who, just how clear does it have to be, and it's you're gonna have boundary cases, no question about it.
Well, I know sometimes, I guess, in lawsuits, it is incumbent upon the decision makers, be they a jury or judges, they've got to apply some degree of subjective analysis. Man, that really seems like Yeah, right, exactly. I mean, I can't tell you the number of times in my business career my attorneys would always say reasonable, and they would always invoke that term, which always applied, especially usually in any sort of business dispute, as you can imagine. But in this case, are we asking the Supreme Court to kind of subjectively rule on whether or not the president engaged in insurrection? And engaged and insurrection, as you just point out, they're subject to interpretation. Both of those terms are.
Yeah, so not necessarily. I mean, so one way to do it would be that when it's fuzzy, every state can kind of decide what they want to do on their own. And some states might say, well, it's so fuzzy, we're just going to defer to the electorate and let them vote for the guy if they want to, because it's insufficiently clear. But Colorado, they said, well, we're not going to require clarity. We're only going to require preponderance of the evidence. Is that decision so clearly wrong that the U.S. Supreme Court has to reverse? So there's kind of layers and layers of, is a decision not to require that much clarity itself so clearly wrong that the U.S. Supreme Court is gonna step in? And the plaintiffs, they said, well, you could. I talk about this. Do it and be legends. They could just say, well, we're going to review it de novo, and we're just going to decide what the right answer is, and the right answer is that Trump can't be on the ballot, and that would resolve everything nationwide. It was very, very obvious that they were not going to do that. So once you get to that, where they're like, oh, well, all we would be doing would be saying that states are kind of within their rights to do it, then you get this problem of chaos, which the court essentially, I think, is going to just say, well, the vibe of the thing is it shouldn't be too chaotic, so they're not even allowed to do that. But there's lots of ways you could say, well, this is how we do it with juries. You have a reasonableess requirement. What action was reasonable in the circumstances? You pick 12 people and get them to agree. They're going to be. It really depends on what jury you get. That's why jury consultants is a thing.
Sure. All right, let's turn our attention to this other case concerning the former president's immunity, which got appealed, and the appeals court rejected the idea that he's immune from any actions, and basically is deemed he's just a regular citizen. What's your take on that?
Well, so the impeachment clause, Article 2, Section actually there's several impeachment clauses. It's at the punishment for impeachment clause. It's actually in the Senate section. So Article 1, Section 3, somewhere kind of right at the end. Judgment in case of impeachment shall not extend further than to removal from office and disqualification to hold any office of honor, trust, or profit around the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So it's very clear the fact that you had an impeachment proceeding doesn't prevent you from being subject to criminal process. And the president can be impeached. That's clear from Article 2, Section 4. The question is, so you can be prosecuted after you've been convicted. The question is, if you've been merely impeached but not convicted, Is that some sort of weird double jeopardy kind of thing? Trump,
Wow.
Made that argument to the D.C. Circuit, and it got rebutted pretty forcefully. I think it really doesn't make any sense to say, if you can get 1/3 plus 1 of the Senate on your side, therefore you can never be prosecuted. And Trump's position was, even if I ordered an assassination, illegal assassination of a rival, I would be completely immune. I mean, that's just, there's no way that could be the rule. Whether he gets some immunity for discretionary acts or something like that, but not for mandatory things, and then we'd have to require analysis. Well, did he violate mandatory duties when he said come January 6th it'll be wild, and all the stuff on the afternoon of the 6th.
We'll be watching
some
it.
questions there.
Man, oh man, we'll be watching it. Interesting. Appreciate you coming on and clarifying all that, Professor Christopher Green. Thanks a lot. See you soon, sir.
Great to see you. Take care.
Coming right back, folks.